Good evening, this is John Milburn for Laws 11062. This is Contract B, and tonight we're continuing with our discussion, firstly with some feedback in relation to the first assessment, some brief discussion about the second assessment, some of the things that you might want to consider in that context, and then illegality. So the topics that we're discussing don't necessarily sync with the topics that appear as the weekly topic. So as you know, I'm a little behind with that, and that was quite intentional and like to continue. So firstly, the first assessment and the way in which you've presented your material overall was very good. Now, I elected to provide some oral feedback on this occasion. I do mix it up a bit, but oral feedback, hopefully that was useful for you. The feedback that I provided to each of you was pretty much tailored to the work that you presented. And if you found that I was talking quite a bit about the basics like presentation, referencing, spacing, pagination, all those basics for the written work, you possibly missed out on some other good material because we've got a limited time, but we've got to get the basics right. Now, if you're in that category where you're not comfortable about the way in which you present your material, please get yourself, as it were, up to speed very quickly because we want to talk more about the substance. But I'm really a bit stubborn about this. I don't like people to move on into second year unless you've got the presentation looking just right. Now, there is no one single form of presentation that's right, but generally speaking, in terms of the content, the mantra, if you like, is communicate simply and effectively. Keep it as simple as you can. It doesn't need to be flowery or elaborate. We're not writing a novel, we're writing something which is intended to impart information for the benefit of the reader as easily and logically and quickly as possible. It's a commercial document. It's not a prose. It doesn't mean you can't use some flair from time to time. Now retired Justice Wilson was a person that I spent quite a bit of time with in terms of the writing style, and he would always promote the simplicity, but he said whenever he would write a judgment, he'd allow himself just one little passage which showed his vast literary skill and training, but generally keep it simple. It's important to present professionally. So things like pagination, consistency of the layout is important. And people say, why do you need to bother about putting in the page number? Well, I guess in simple terms, if you've got an extensive document and the judge wants to talk to you about something in that document, they don't want to be saying, well, go flick through and it's the page that commences with this word. They want to say, go to page 7, paragraph 2. So do you get the idea? It's part of professional presentation. And remember, of course, that when you're preparing your written communication, plan your thoughts, use headings, professional presentation, ensure it's well referenced, and where possible, reference primary sources, not secondary sources, write in a logical, fluent style, and write as though you're trying to communicate something, which means plain writing, concise, write in the active voice. We all know the active voice versus passive voice. Jim told the tribunal that the victim lost consciousness is one way of saying that's a good way. Another is saying the tribunal was told by Jim that the victim lost consciousness. Not as good. That's the passive voice. And if you're thinking, well, aren't you really telling us to do something that's very simple and therefore we don't have to work as hard? In reality, it's quite the opposite. And a short document often takes more time to prepare than a longer document. So if you aim to provide something that is very well written, it should take some time. The other thing is, remember, of course, that it needs to be presented on time. Congratulations, this cohort is excellent in terms of presenting material on time. So well done, and please keep that up. It's a very good habit to develop, And of course, for those of you that want to practice in the profession, it's absolutely mandatory. If you've got a court date, you've got to be ready on that court date. If you've got a settlement for a conveyancing matter, you've got to be ready on that day. So there's no ifs and buts and, oh, that's near enough. It's pretty hard-headed type profession. So aim to develop your skills at this early stage and carry them forward. If you've got any doubts about the presentation, have a look at the sample document, and then you can go on and try and develop a few more skills, such as avoiding finishing a sentence with a preposition, which is one of my little dislikes. And also try to minimize the words. For example, instead of saying, I read through it, you could simply say, I read it. Do you understand? It's only one word, but that's what I mean in terms of simplification, and sometimes it takes a little longer to write. So ask yourself, can you simplify? Now, we don't need to be silly about it, and I don't want to discourage the creative use of language, but I hope that you get the idea. It's a bit of a balancing act. The reason I mention it in first year a lot is that, if anything, the tendency of students, in my experience, is to write in sentences that are too long, paragraphs that are too long. Try and keep it simple. With your referencing, overall, very good. Wherever possible, use pinpoint referencing, and the cohort did very well in that regard. People sometimes say, well, where do I look to get an idea of how this should be presented? Well, apart from the sample document, there's the notes, the study guides, but also if you read most textbooks and you read cases and you read articles, it provides you with a good idea generally. Now, there's a word of warning here. The older cases tend not to be ones that you'd want to emulate, because they were written in a style which was prior to the plain English, the plain language, almost revolution that hit the profession in about the 80s and the 90s, which has developed beyond that. When I first started practicing in law as an article clerk in the early 80s, I'd read, for example, a mortgage, and it was almost incomprehensible in terms of the length of sentences, the use of legalese, and basically a lot of nonsense. That all stopped and started to change in that period of 80s to 90s. So some of the older cases probably would teach you some bad habits, but you'll get to know some of the judges that are very good in terms of their communication. I've mentioned one, Justice Wilson, now retired, of the Supreme Court, formerly Judge Wilson. He was President of the Queensland Civil and Administrative Tribunal. So he's a very good one to follow, for example. Now, the second assessment is all about oral presentation. And in that regard, can I commend those students that have been involved in some very good collaborative discussions online? Please continue that. Now, you know for the second assessment that you can choose either of the parties. You can either act for the son or the parents as you see fit. And in that regard, develop your skills. And I'm pretty sure it is only, did I specifically say don't act for the bank? I can't recall, but you can, any of the parties that are involved in the litigation, I'm happy for you to act for. Whatever you do though, please ensure you've learned from, I think, the feedback that I generally gave in the first assessment, and that is, please consider this from the perspective of both or all, as the case may be, parties. There's a real trap in law to fight for your client's rights, and that's good, but it loses focus in two areas. The first is that within the context of fighting for your client's rights, you must do so subject to a paramount consideration. I'll open this up for everyone except Chris, sorry Chris, to tell me what they think the paramount consideration might be when you're acting as an advocate, and it goes even above your duty to your client. Any thoughts? If we don't get an answer, I'll bring Chris in.
Bridget's put something in the chat box, but I was just,
Yes. Yes.
Would it be that we're trying to look at what the law precedent is overall, rather than looking at whose side is the winner?
Yes, you're along the right tracks. And Alex has actually got the exact words that I was looking for, which is the duty to the court. So thank you very much for those contributions. Now, in court, you hear this phrase a lot. What's your authority for that proposition? So if you said to me, and I'm not just picking on you, Alex, and I'm opening this up generally, if you said to me that your paramount consideration is, as an advocate, duty to the court, what would be your authority? If I said, well, what's your authority for that proposition? What would your answer be?
Sorry, I'll just jump in with my video. I think it's like upholding the legal system in general so that the public have faith in it. Yeah, I don't know
Yes.
if I can explain it more.
No, that's good. Some ancient content, says Bridget. That's close. Not quite. All right. We need to brush up on our ethics skills. So as lawyers, and therefore as law students, you have obligations to look at matters from an ethical perspective at all times. Remember, of course, that the threshold learning outcomes that we ask of you when you're studying law go well beyond knowledge. If I can borrow from the new lawyer, for example, that many of you may have used, there are 6 self-threshold learning outcomes. The first is knowledge. The second is ethics and professional responsibility. The third is thinking skills. Fourth is research skills. 5 is communication and collaboration. And 6 is self-management. So this second assessment really deals with a lot of those. And what I'm asking you now to do is look at and consider the ethics side of the professional responsibility. The hint that I'm going to ask you to follow up on is look at the Australian Solicitors' Conduct Rules and look at the Barristers' Rules. You need to consider both those within the context of the second assessment. Now, it may be that you don't add anything, delete anything, or change anything to the presentation you might have otherwise given for the second assessment. But in every assessment piece that you have in this study from now on, I'd like you to at least turn your mind to ethics and professional responsibilities. The Australian Solicitors' Conduct Rules and the Barristers' Rules, they're not terribly difficult to read, and if you want an external resource, which is absolutely excellent, championed by Stafford Shepherd at the Queensland Law Society, have a look at the Ethics Centre on the QLS website. And indeed, if you really want to become even more part of the profession, I would urge you to consider becoming student members of the Queensland Law Society. And please consider becoming a member and involved in the Law Society for Central Queensland University. Have I got that right, Chris?
Very much so. They both, it's actually really quite amazing how much the Law Society for CQU, but also for the Queensland Law Society is actually doing for students. I've been working with the Queensland Law Society with mature age students and helping processes to get them into the industry. So yeah, I recommend that for both, absolutely.
Great. And you know, it is nice to have that sense of belonging. So you belong to both CQU and the profession. And I think I may have mentioned in week 1, feel as though you're part of the profession now. Even if you don't intend to practice in law, you know, feel as part of the group. So ethics and responsibilities, keep that in mind whenever you're undertaking your work. Now, in the Australian Solicitors' Conduct Rules and the Barristers' Rules, you'll see that at an early stage, like Rule 3 or something, is your paramount duty is to the administration of justice, which really means in the context of this assessment work, your duty is to the court. And what that means is that you don't necessarily advance every argument, and you certainly don't advance arguments that are unlawful, unethical, or improper. So you can't say whether they're improper, for example, unless you've had a look at those guiding rules. Now, I think the Australian Solicitors Conduct Rule and the Barristers Rule is on Moodle website, somewhere in the research areas. If it's not, please let me know and I'll try to remember to look, but I'm pretty sure they're there. And the Ethics Centre, as I mentioned.
They are there, John.
They are great. Thank you, Bridget. So please don't think I'm overloading you with too much work, but it's really important now and into the future. So for the second assessment, you need to be on your feet, as it were. You're presenting something for me to consider, I guess, as the judge in terms of the content. So what do you think I'm looking for in that assessment? I'm just going to ask you to just take a moment to think of a few words that come to mind as to what I'm looking for. What am I trying to, what are you trying to achieve? Yes, Natalie?
Be something along the lines of obviously our argument, so what we are seeking, and to back that up in relation to case law and legislation. Yes,
be clear about what it is that you want. There's a, there is a way of looking at this, and that is the judge will look at you and say, well, firstly, who are you? So you've got to announce your appearance, and then say, why are you here? What do you want? And on what basis am I allowed to give you what you want? Do you understand? So you've got to be clear. I'm Mary Smith. I'm here to represent the plaintiff. I want an injunction, and Section 114 provides you with specific power to grant me what I want. Having told you that, now let's see if I can get there. Make it clear. You don't want me sitting there for, 7 minutes and still not really sure what it is that you're asking me to do or what authority I have to do that. So thank you, Natalie. That's very much along the lines of what I'm after. What are some of the key attributes of a good legal advocate, do you think, that you'll need to demonstrate in the second assessment? Any thoughts? Nothing coming through yet. Yes, Bridget?
Would you be talking about just our presentation in general and actually
yes.
knowing what we're talking about, like practicing it before we present it?
Well,
perhaps?
If you're really good and you can present it without practicing, so much the better. But yes, your presentation and the content, the two need to work together. Presentation. Look the part as best you can. Obviously, don't turn up in a t-shirt. So, and if you don't have a coat or you don't have a tie, that's okay, but do the best you can in terms of your physical presentation. You might be standing for this, would be possibly better than sitting. I'm not prescribing that, but that would be usually the case. As you rise to your feet, as it were, think about the opening sentence, think about the way in which you present yourself and project in a way that I can hear and at a pace that's just right. And you'll say, well, what's the pace that's just right? Well, it's a pace that's not too slow and it's not too fast. Sometimes when advocating, people tend to go too quickly. So if there's going to be a common mistake, it will be people rushing. So stand up, try to be as confident as you can, enjoy the process. You can smile if you like, it's okay. It's not meant to be torture. And remember, of course, that I'm interested in what you have to say and I want you to do well. So think of the court as the court's not your enemy. Now, why isn't the court your enemy? Can anyone tell me that?
Ask a random question quickly, John.
Yes.
I'm really concerned about the pronunciation of every single case. Like, I keep thinking about, how am I going to know that I'm saying all this stuff properly?
I'm sure I mispronounce case names all the time. Just don't fall into any obvious errors by saying verses, for example, as we've discussed earlier, but don't worry too much about that. You know, sometimes you can, you know, run it through Google or some other program to get a pronunciation, but don't worry too much. All right, so why do you think the court wants you to do well? Any thoughts?
We've pretty much only got a 50% fail rate.
There is
One
that.
party, I guess, is going to get what they want.
Well, but that doesn't necessarily mean that the party that gets what they want get a better mark than the opponent. It's quite possible that I say, no, I'm not going to give you that, but boy, that was good. HD. Yep, all right, I'll give you what you want. Not very good presentation, pass. Understand what I mean? So don't worry too much about the end result. It's formulating the argument and backing it up in a proper manner. I'll tell you why the courts want you to do well, because to a large degree, courts are relying upon you to feed them with the accurate information they need to make the right decision. Ultimately, courts want to make the right decision. And they may go into a case thinking, I'm 95% sure, having read the material, that I'm going to find in favour of the plaintiff. But the defendant then has to ensure that everything which is relevant to the defence is fairly put to the court, so the court can make the right decision and not the wrong one. So if you, the court wants to know that you're credible and you've done your work and they can rely upon you. And that means having confidence in the way you present yourself, but more importantly, having substance to your argument that's well researched. Any questions then about the second assessment? We'll talk more about it later, but that should do for the moment. Remember, of course, your legal research skills. Think about how to answer a problem. Make sure that you're using well-researched and referenced material from reliable sources. Use the IRAC methodology, but don't slavishly use that, as you probably heard me say, in feedback for those that may have used the actual headings. Natalie, did you have a question? No? Okay. All right. So, and remember, of course, to cite your research and, where possible, provide reference to the authorised case. So, for example, in the Commonwealth sphere, the Commonwealth law reports are authorised. The Federal Court reports, the Queensland reports, they're the authorised set of reports. So you can read about a case you can, from a number of different sources, but they're not always authorised reports. I hope that makes sense. Let's talk about illegality then. So illegality in the context of contracts is that material which is covered in chapters 18 of your text and 18 of your casebook. And you'll see in the study guides reference to some of the key terms. In practice of the definitions and the key terms, administration of justice is important and restraint of trade is important. Now, administration of justice relates to the broad activities that go towards operating a fair and transparent justice system. It's all tied in with the rule of law. And that's part of the paramount consideration you need to bear in mind. And bear in mind that lawyers are officers of the court. So in terms of your advocacy, for example, you have a key role in ensuring that the administration of justice is administered fairly and appropriately. Now, restraint of trade is an area that limits the freedom of a party to act in a way that would otherwise be lawful as a result of a contract arrangement between two parties. And typically, we see restraint of trade in the context of the purchase and sale of a business. To a much lesser degree, we see it within the context of employment contracts. The reason we don't see restraints of trade typically in employment contracts is because there's a particular legal reason why it's not very useful to include such a restraint in a contract of employment. Does anyone know why? It's okay if you don't. It's to do with public policy, and the public policy is part of our justice system where it's like an overriding policy, and courts will find that it's against the public policy to stop someone from lawfully undertaking work somewhere else. So restraints of trade in employment situations are very hard to enforce. Less so for businesses. So if someone pays an amount of money for goodwill for the business, which in part is reliant upon the seller not competing with you once you've paid the seller the money, then courts will generally uphold a lawful restraint of trade. Now, there's a particular type of drafting relevant to restraints of trade, which is called blue pencil drafting, or there's various names for this. But sometimes if you see a contract, you might see a restraint of trade that's like multiple choice. I don't know if anyone's seen this in the past, but it may be, for example, that the seller of a business is restrained from operating in competition within 100 kilometres, 50 kilometres, 20 kilometres, A, B, C, for a period
I've actually
of...
signed something similar to
Have
this
you?
before. Yeah.
Okay. Do you want to tell us what, without going into details, or Bridget, do you know why it was like that?
I was hairdressing, so I'm working for, there was salons that were together. They sold the one salon to another lady, and I had to sign that within certain area I wouldn't work, or I wouldn't try and take clients from that salon that I had been at.
Yes, yes, and that's the restraint of trade provision. But coming back to the sort of ABC, the basis for that is, even though it looks, well, how can this be certain? Courts regard it as certain because they generally look at the most onerous of the restraints and ask, is that reasonable? And then they might say, no, that's not reasonable. We'll cross that out, the blue pencil ruling through that one. Is the second restraint reasonable? No, that's not reasonable. Is the third restraint reasonable? Yes. I personally don't like that type of drafting, but you may come across it. And when you see it, it doesn't necessarily mean that the contract is void for uncertainty. It's just a particular type of accepted form of drafting for restraints of trade. Now, in the context of illegality, we have different types of contracts, don't we? And essentially, a contract may be signed by the parties, it may appear to be enforceable, but ultimately it may be rendered unenforceable as a result of being declared illegal or void at common law. And in this area of practice, as is a lot of the work to do with contract law, there's a lot of case law involved in this. But contracts can be illegal by statute, they can be illegal at common law, or they may be void under statute, or they may be void at common law. So there's a whole lot of different options that might apply in these circumstances. One thing that I will mention is this word void. Typically we see this within the context of something which is voidable at the instance of one party or the other, and the court may declare it to be void as a result of something being brought to the court. But essentially there are two meanings for this. So At law, when something is void, essentially it means it has no legal effect and it's unenforceable at law. Now, it sometimes means the act in question has not and never has had any legal effect. Do you know the Latin term for that? Has anyone come across it? It's void something something, meaning it never has had effect, it's never had and never will have any legal effect. Bridget, well done. Void ab initio, that's the term. Otherwise, it means the act becomes void against everyone, and certainly against those who can't enforce it or take advantage of it subsequently. And sometimes the terminology is confusing, and void is meant to be the same as voidable or voidable at the election of one party. So unfortunately, there's no settled single meaning on this, and you need to be a little robust. But the general rule is if we're talking about something that is void, that means it has no effect. That can be, as I mentioned, as a result of statute law or common law. You know, the statute might say, in the Tax Act, for example, it might say any transaction which is entered into with a specific purpose of avoiding tax is void. So that's under statute. Or it might be that there's case law that suggests that this type of arrangement is void under common law. So they're slightly different terms, illegality and void. Now, voidable, as I mentioned, is where it's capable of being set aside, which means it may become void, but only if some action is taken by a party or an order of the court. So if the contract is voidable, it remains operative until it's voided by operation of law. An avoidable contract is one where the validity can be challenged due to the quality of the consent, for example, or it may be that the party can rescind the contract for matters affecting the vitiating circumstances, ones we've talked about, such as misrepresentation, mistake, duress, unconscionability, and undue influence. So this is where it needs to be clear what we're talking about, and the terminology is not always consistent. So prepare a toolkit as best you can, identifying what you think is the appropriate meaning for these various words that you see crop up, and have some authority for your proposition. So it might be a legal dictionary. It might be something out of LexisNexis or Westlaw. It might be in a case or a statute. But just have some go-to method of determining what you think these things mean. And remember, of course, the difference between rescission, termination, and one of the things that did crop up in the first assessment was the question of, well, whether, wasn't it Kareem had actually affirmed the contract, because if Kareem had affirmed the contract, then arguably it's too late for him to have rescinded the contract because the two don't sit together. There's a lot of words. I hope that makes some sense. But please do some research and do some preparation to assist yourself in those circumstances. Now, I mentioned that contracts might be illegal under statute. And there are 3 circumstances where that might occur. These are in your notes. It might be an express statutory provision, something that's very clear. It might be an implied statutory prohibition, or it may be there's no direct contravention, but the contract is associated with or in furtherance of some illegal purpose, which will then render the contract tainted and subject to it being declared to be invalid. So when you're looking for the express statutory prohibition, look for direct words. The case in the notes, I think, is Mahood and Isbahani. I'm not sure if that's the right pronunciation, Bridget. It probably doesn't matter, but you know what I mean. So there was an order made under the realm of the defence realms. A person shall not buy or sell or otherwise deal in linseed oil except under licence. There was a contract. The defendant refused to accept delivery, and the action failed because the order clearly prohibited the sale of linseed oil in those circumstances. So it was pretty much a straightforward instance of express statutory prohibition, rendering what would otherwise on its face appear to be a void and legal contract illegal. Another one is Pham and Doan. It's a 2005 decision from New South Wales, and a pharmacist formed a business partnership with someone who was not a pharmacist. The partnership agreement was held to be illegal and void because, at that time at least, in that jurisdiction, the business partnership had to be between pharmacists. It's a bit like that with lawyers. It's changed a bit with incorporated legal firms these days, but for many, many years, lawyers could only operate in partnership, and you could only be a partner of a law firm if you were admitted to practice in law in Queensland as a solicitor. All right, so any questions then about express statutory prohibitions, or is that all clear enough? All good? Implied's a bit trickier. It can occur when the statute doesn't expressly state that something is prohibited or illegal. What do we then need to do? We need to consider what the words meant or were intended to mean. Then we're going back to statutory interpretation principles, aren't we? So we're looking for the intention. How can you best identify the intention of Parliament if that's your argument based on the intention of a statute? Any thoughts? Where would you look?
You can look at the second reading speech or the preamble.
Yes, excellent.
Does that get used much in court, like the Acts Interpretation Act?
It does, yes. I mean, depends on what court. I mean, if you're in the magistrate's court and it's traffic day, it would be very rare. You know, it's normally, drink driver, here's the fine, here's the disqualification, next. But if you're dealing with a matter in the Supreme Court, particularly in the Court of Appeal, oh yes, very prevalent, very common. And it'll still apply in the lower courts, but to a lesser extent. But don't ignore it. These are important principles. Probably one of the most cited cases in Queensland would be Project Blue Sky. We all know that from ABA. So it's always useful to toss that in somewhere in a discussion appropriately. Right, all good? Thank you, Craig, for that. So implied statutory prohibitions, have a look at what might have been the intention. The example in the notes, Cape and Rowlands, talking about stockbrokers and unlicensed brokers in England. And there may be negative consequences for the innocent party if a contract is void or made void. And have a look at Yango Pastoral and First Chicago, Australia. So in that case, there was a question about whether the statute simply provides for a penalty for a certain prohibited conduct, and the court said that they may enforce the contract, enforce the penalty. The penalty was applied, but the underlying mortgage contract was still held to be valid. So that's where it can become a bit of a hybrid situation in terms of any answer that you might give. Now, probably a fairly common type example of a question around illegality is where there's a contract entered into in furtherance of an illegal purpose. And Fitzgerald's case is in the notes in that regard. And what you're therefore looking for is the scope and purpose of the statute to consider whether the purpose will be fulfilled without regarding the contract is illegal. And then I mentioned earlier public policy. So when we come to the common law, we're dealing with some basic common law principles, and one of them is public policy. So contracts can be illegal at common law because of public policy, in the same way that courts can render conditions of no effect because of public policy. So public policy works both ways. For example, a contract will be held to be illegal at common law because of public policy considerations if the contract is to commit a crime or a tort or a fraud. So good luck if you're a hitman seeking to claim your, I don't know what the going rate is these days, on an unpaid contract. And I'm being half facetious, you understand. So a contract to avoid payment of tax would be illegal, but a contract to minimise tax is regarded as legal. A contract to pay a witness not to testify is illegal, but a contract to pay the expenses incurred when a witness does testify would be legal. So what are the consequences then of illegal contracts? And it goes beyond the usual notion of being declared void. And there are a few general principles here. One of them is that courts won't assist someone found in their case upon immoral or illegal acts. That's Holman and Johnson. Generally, neither party can recover any money that's been paid through their involvement in such a contract. So unlike void contracts, which are considered, void ab initio, considered non-existent and title doesn't pass, usually money or property transferred can't be recovered in restitution if it's an illegal contract, even where there's a total failure of consideration. So the general rule of no recovery is not absolute, and there are some circumstances in that regard. I mean, one of the cases you might consider for a whole range of reasons is Nelson and Nelson from 1995, 184 CLR 538. And that was an example of a case where a party might claim under an illegal contract. And if one part of the contract is illegal, it may be possible to sever that unlawful part of the contract and give effect to the rest. An example is the Nordenfeld case. One of the promises was too broad, but not to, but the promise not to manufacture guns was not too broad. The rest of the contract continued to operate. Now that ties in a little bit with one thing I mentioned earlier in the context of restraint of trade. You'll recall that I mentioned courts do at times take it upon themselves to adopt a certain interpretation of a contract by deleting parts of the contract. The same sort of thing in Nordenfeld's case. So it is possible to salvage part of a contract even though part of it may be illegal and declared void, as it were. Now a statute can declare a contract void in a number of ways. I was talking before about statutes declaring contracts illegal, but statutes can declare some contracts to be void. So have a look at Yango Pastoral against First Chicago, Australia. The citation is 1978, 139 CLR 410. So it can be made void if the contract is to do something that the statute forbids, prohibits, and that's the combination, forbids and prohibits. So number two, sorry, it's been a long day. Number two, if the contract itself expressly or impliedly prohibits the statute. Number three, if the contract is to put into effect a purpose that is rendered unlawful, or if the contract is to be performed in a way that the statute prohibits. So these are all options. Now, have a look at the Australian consumer law. As a guide, do we all know how to find the ACL? I guess we can always Google it, but do we know where to find it? All right, good. Schedule 2 of the Competition and Consumer Law. Have a look at section 464 in that regard. And it says, a term will be void to the extent that it purports to exclude, restrict, or modify any of the statutory consumer guarantees of the ACL. That's a handy one to keep in mind because those consumer guarantees under the ACL are almost sacrosanct. Okay, so in relation to this area, some key points. I've mentioned a statute may make the contract void in 4 ways, but don't overreach. For example, a statute will not make a contract void if the contract is to do something that the statute forbids by implication only. The contract would be void if it was to do something that the statute forbids expressly. Here's an example. If a contract required the payment of, we used to call it stamp duty, but transaction duty. We all know what I mean by that. If you buy a house or a car, you have to pay duty to the state government. Let's call it stamp duty to use the old terminology. So if a statute required the payment of stamp duty for a contract, let's say it was a building contract, then the question is, would completion of the building task without payment render the contract illegal? It would be impliedly prohibited, but the contract itself would not be void. There may be some hoops that the claimant needs to go through, for example, having to pay the stamp duty before a court will enforce it. But the failure to pay the stamp duty in that situation does not of itself render the contract illegal. Now, I mentioned contracts are void at common law if they're contrary to public policy. I mentioned earlier restraints of trade, and I said these are some of the ways in which courts will look at restraints of trade. Now, the court will ask themselves a few key questions in the context of being void at common law against public policy in a restraint of trade. And the first question is the restraint reasonable and in the interests of the parties? And the party seeking to rely upon the restraint has the onus to prove that it's reasonable. And the second is the restraint reasonable in the interests of the public? And again, the onus is on the party seeking to strike down the agreement. So the questions for the court are the legitimate interests being protected? And is it necessary on public policy grounds to protect those legitimate interests? It goes beyond what is necessary, it is not reasonable, and it's therefore not enforceable. Okay, any questions? I know I've moved very quickly, and thank you for your efforts. What I propose to do is, it's a little early, but I know some of you have got a 7 o'clock matter, so I'll wrap it up fairly soon. But before we do, are there any questions, comments, concerns? All good? All right. Perhaps I could go just a little longer. And in terms of restraint of trade, the restraint is likely to be valid in one of 2 circumstances. Number 1, where the business is sold, but the restraint must be reasonable, as I mentioned earlier. Have a look at Nordenfeld, 1894 appeal cases 535. And secondly, in the context of employment, where the employee is restrained from leaving their employer and setting up business in direct competition. So that's Atwood and Lamont, 1920, 3 King's Bench 571. Sometimes contracts seek to oust the jurisdiction of courts. Now, a contract inherently creates rights and obligations, and the intention of those rights and obligations is that they should be enforceable. So a provision in a contract preventing court action is on its face void as being contrary to public policy. Have a look at the case of Dobbs against National Australia Bank, 1935, 53 CLR 643. All right, thank you very much. So that's our flying visit to illegality. Next week, we'll look at the week 6 material, discharge by performance or agreement. Okay, all the best and enjoy the process of preparing for the second assessment. and we'll see you next week. Bye then.